My goal is to give you an overview of humor in the law in terms of the different avenues for analyzing how those two come together. I'm going to do this by giving you an idea of my own scholarship, which in fact does span in part, it does span the universe of how law and humor meet, collide, and the like. Some of us were practicing lawyers, some of us are practicing lawyers, um, and others of us come from the idea, this interdisciplinary study from so-called non-law disciplines, cultural studies, media studies, and the like, and for some mysterious reason have become fascinated with law. I was a full-time practicing lawyer before I entered into the legal academy. That was a long time ago. And I still occasionally, time to time, take on some cases. And I just wanted to make a shout out to one of our close colleagues, João Capellotti, who practices law in Brazil and was unable to join us today. So the way in which I divide up the study of humor in the law is to look at, first, law's effect on humor. Second, humor in the law. And third, humor about the law. So we're talking about on, in, and about. The first category, laws of effect on humor, is probably the most rigorous in the sense of you need to do a deep dive for each particular problem or issue into legal doctrine. I have, over a series of studies, looked at law's effect on humor in the context of contract, tort, which is the law of wrongs, intellectual property, defamation, and employment discrimination. And that's a fair cross-section representative of law. It has the three pillars of the common law: contract, property, and tort, the law of wrongs, in addition to federal law and state law, statutory law, and case law. My focus, because that's what I know, is on US law. So what I mean by law's effect on humor is that it turns out that there's certain types of comedy that the law likes, that it preserves, that it protects. There's other types of comedy that the law punishes, tries to prevent from occurring. And you can see a trend in all these different areas of law. So I'll give you a couple examples just to bring it alive. My first example is a very famous case that many of you may have heard of. It deals with the Pepsi company and an advertising campaign that they had put in place, sort of a typical advertising campaign that's part of marketing, encouraging people to buy the product and save, in this case, bottle tops. And each bottle top had a Pepsi point. And the idea is you could save up the bottle tops and get valuable merchandise if you had enough of them. So Pepsi decided to do this advertisement in which they featured a young man, a young kid, an adolescent, who is getting ready for school. He starts to go out the door. His parents throw him the keys. He throws his knapsack over his back, and he gets into his Harrier jet. The idea is that he is using a Harrier jet as a way to get to school. A Harrier jet is one of those aircrafts that take off vertically and are used in military exercises. So at the beginning of this, let me share my screen here. at the beginning, like one of the first frames of the advertisement shows the Harrier jet taking off, and then him arriving at school saying, "Sure beats the bus." Then the next slide, the last slide of the commercial says Harrier jet 9 million Pepsi points. So the idea is if you could amass 7 million Pepsi points, you could get yourself a Harrier jet. Well, some kid in I think it was in New York, some kid worked out a scheme where he amassed 9 million Pepsi points. That is with trading and the like. So he went to the Pepsi company. He said, "Here's my 9 million Pepsi points. Where's my Harrier jet?" The Pepsi company said, not surprisingly, it was a joke. It was meant as a joke. Well, he claimed that it was not a joke, that the advertisement was an offer that was capable of acceptance, and he is now accepting it. And he's accepting it under the terms in which it was offered. So under contract law, it's pretty straightforward. You need an offer, an acceptance. You need some sort of value to change hands. And you need to be the parties communicating in a way that they're manifesting an intent to be legally bound, right? So this really turned on whether or not, in fact, there was this manifestation of intent to be legally bound. So the Pepsi company refused. You're not going to get your Harrier jet. He filed suit in the United States District Court for the Southern District of New York, which is one of our nation's proudest forums. And he filed a breach of contract action. So what did the court do when they were confronted with this lawsuit? They evaluated whether or not it was a joke. Right? They were put in the position of trying to figure out whether or not it was meant to be funny. How did they do that? They looked at incongruities in the advertisement, suggesting that they did not have the intent to be legally bound, that they were making a joke. And this was the beginning of my thinking, it looks like they're relying on incongruity theory, that is the juxtaposition of two things that you don't normally see together, and so there's surprise element. Although they didn't purport to be using humor theory, that's exactly what they were doing if you look at their analysis. So, for example, the court said, this is ridiculous that you would think that a young man going to school would be using a Harrier jet as a means of transportation when he probably couldn't even be trusted with his parents' car keys, right? We have like a highly improbable pilot. We have, in fact, just an exaggerated the adolescent fantasy that's being presented here. So it decided, the court, that it was sufficiently incongruous to suggest that it was in fact serious and denied liability. So that's a good example of how you look at the elements of contract law, and what the court is basically doing is just saying, you're not making out all the elements. So it's not saying we want to protect this humor. It's just saying we're going to read the elements of the claim in such a way that we're not going to impose liability, because that would be, in a way, punishing the joke. But they don't do it in the frame of we're trying to protect the joke. Now, to move on to constitutional law, the approach that law has is, in fact, to protect the humor, because it serves some kind of function deemed essential to human rights, essential to the functioning of government, and the like. So an example of that is the case, which is also pretty well known, dealing with Hustler magazine. And And in this particular instance, it's again an advertising campaign that's being riffed on, that was ran by the Campari company that had this sort of series of advertisements where they got famous people that talked about their first time drinking Campari, when in fact it was, you know, a riff on your first time having sex. In this particular parody ad, which appeared in Hustler magazine, what Hustler did is it had the exact same format. It looked just like the original, but if you read the text, it describes Jerry Falwell, who was a televangelist minister, on an very big public figure in the US at the time. Jerry Falwell describing having sex with his mother in an outhouse. He filed suit against Hustler magazine. Hustler magazine filed a number of claims. What went up to the United States Supreme Court was a claim known as intentional infliction of emotional distress. And the idea is that someone could be liable for a dignitary harm to an individual if what they said was so outrageous that it was clear that it would in fact inflict intentional distress. The United States Supreme Court slapped down the claim, dismissed the suit, because in fact it concluded that this type of parody was protected by freedom of speech principles under the United States Constitution. And what it did was it brought out case law that said, yes, you can sue a public figure for making fun of them, ridiculing them, criticizing them, but it must be shown that number one, what you said was false, and number two, that you published it with knowledge of the falsity or reckless disregard of the falsity. And the court said it's preposterous to think that standard is satisfied here. So the court dismisses the case under the First Amendment's protection of freedom of communication. But in the process, the court provided what I would call a love letter for parody. And you'll see this come up a lot with intellectual property law, and you're going to be treated to some great examples from Sabine Jacques later on today. Okay, so that gives you an idea of law's effect on humor, right? By its operation, it's either intentionally protects a certain type of humor, or it in fact punishes other types of humor that it doesn't like, and it concludes that in fact a legal claim can proceed. Now, moving on to a different context, I'll talk about humor in the law, right? And to me, this is actually probably one of the areas where you see the sort of most charming, funny stuff, at least in my view. And I think the reason is that generally what comes up in humor in the law, you know, that is in a legal text, in a courtroom, a judge, a lawyer, some sort of document that's filed, a will, a contract. Generally, the funny stuff that appears is unintentional. It's just the foibles of life, right? Human mistakes, humans being silly, and the like. And that, to me, that type of unintended spontaneity is something that it evokes probably the most sincere giggles. But you can come up with your own conclusion on that. But to give you an example of humor in the law, I'll tell you about one of my favorite cases, which was a case that actually started in a very unlikely context. And that happened to be a primatologist that was studying macaque monkeys. He was in the field with the macaque monkeys and had actually developed a relationship with this group of monkeys. And they were sitting in a circle. He had his camera, he had his notepad. He put down his camera to pick up his notepad and to take notes about what was happening. And unbeknownst to him, one of the monkeys, who we now know is Naruto, snapped a picture of himself. In fact, snapped several selfies of himself. So the primatologist doesn't know this happened, goes back to the base camp and discovers these very charming photographs and uploads them on the internet. Sort of as a matter of scientific interest, maybe sharing the charm with those that followed his work. Well, fast forward a while, an animal rights organization in the United States called People for the Ethical Treatment of Animals decides that this is a violation of Naruto, the monkey's copyrights. Files suit on behalf of Naruto, claiming that the primatologist violated their copyright, Naruto's copyright. Now, here we have humor in the law, right? Because it's just a set of case facts that comes to a court. Lots of times in litigation, you'll see lawyers, in my view, generally making a mistake by trying to be funny. Like, really, the received wisdom is lawyers rarely succeed in using humor to their advantage. In this particular instance, there's an exception, and that is that after the copyright case was filed, the lawyers for the primatologist filed a motion to dismiss the case, which is a summary motion. It's at the doorstep of litigation. It's kind of like, let's get rid of this. It's not meritorious. And in their brief supporting their motion to dismiss, they started with the following: a primatologist, an animal rights organization, and a monkey walk into federal court. What sounds like the setup of a joke is really happening. Monkey see, monkey sue is not good law. This case must be dismissed. And the reason I say that attempt at humor was successful is that the case, number one, was dismissed, and number two, in the court's opinion, dismissing the case, it started with that quote from the brief. So it obviously had appealed to the court. Other instances where lawyers have made jokes in court proceedings are sort of notorious for backfiring. One of the more famous was the oral argument before the United States Supreme Court in Roe versus Wade, the original decision recognizing a constitutional right to abortion. And the person that went first was a representative of the state of Texas, which had an outright ban on all abortions. And the question was whether or not that was unconstitutional. And on the other side, representing someone that was unable to get an abortion in Texas, were two young civil rights lawyers, women, attractive, whole thing, in their little business suits. The man gets up. This is the representative, the Attorney General of Texas, and the first thing out of his mouth is, "When a man argues against two beautiful ladies, he's gonna lose, right?" And the response, I listened to the oral argument on tape, and the response was like dead silence. Joke fell totally flat. And there's another example from a famous case dealing with a vigilante shooting just a young black man who was walking in the neighborhood. And it was a homicide case. It was a murder case, and the attorney for the defendant who had shot the young man started his opening statements with a knock joke, which he had made up. Again, fell straight face down. Did not work. So you see a lot of attempts at litigation in litigation and in the actual courtroom of people trying to be funny. Judges generally get away with it more because after all, it's their show. But it's not just litigation where you'll see it. There's funny contracts. For example, Michael Cohen, who was the individual that wrote the contract for Trump in the Stormy Daniels dispute, sort of a current event at the moment. It's now going to trial. He had so many legal terms and outrageous, complicated legal terms, unnecessary, and he had sub sections of subsections of subsections of subsections. It's just like a comically, ridiculously confusing contract. So you could call that funny. You have athletes that have put odd requests in their contracts. One athlete put in his contract that he wanted the league to buy him a bulldozer if in fact his team won a championship. He got his bulldozer and the like. There was a musical group. This was actually kind of clever. A musical group that put in their contract that the different forums where they presented had to have backstage for the musical group a bowl of M&M candy with all the brown M&Ms removed. And you say, well, that's random. What's that about? And their explanation actually was pretty interesting in that they would check to see if in fact that was done, and if that was done, then they had a lot more comfort in believing that in fact all the more important specifications like lighting and safety that had been set forth in the contract were complied with. Funny wills, lots of funny wills. Generally, they take the form of what I call last laugh wills. The German poet Heinrich Heine had a provision in his will that he left all his assets to his wife so long as she remarried. When asked why he had put that in the will, his response was, well, then at least one man will regret my death. So you have a lot of ways in which wills are used to sort of put that final knife in a loved one. Humor about the law is actually significantly less funny in my view. When I say to you, what kind of ways does humor come out when you talk about law or lawyers? They're lawyer jokes, right? That's a very common trope in lots of different societies. At least in U.S. society, I think it's an outworn trope. I think everybody knows that they're not funny and they're fulfilling some kind of other emotional need. But you also have judge jokes. Judges are depicted as vain or haughty, self-important, and the like. Juries are often depicted in jokes as lazy and stupid, not following instructions. And I do see a theme in all these, in that what it's really ridiculing is an entity that has power. The jury has power to decide the verdict. The judge has power over the courtroom. And the lawyer is in a position of having power to the extent that most people go to lawyers because they're in a vulnerable position. They're somebody has died, their kid's been arrested, they're buying a house, which is a stressful event, and they have to rely on a lawyer. So it's a way of, in fact, relieving the anxiety and maybe the resentment of the fact that you're giving up some power. So that's pretty much all I have in terms of an overview. I can give you lots more examples if you want to ask in the chat. But at this point, I'd like to stop to see if, in fact, there's any questions. And I see in the Q&A there are two questions. Could you explain the parity situation again? Okay, I want to defer to Sabine to some extent on this. So I won't give you a in-depth explanation, but after she speaks, I can talk a little bit more about U.S. law. So the idea with parity is that, at least as it's regarded in the United States as a matter of law, something qualifies as a parody if it is in fact enough like the original of what it's parodying, but sufficiently unlike the original that in fact it's not the actual original. So if you think about the parody of the Campari ad, the actual form and the pictures, the size of the Campari bottle, the fact that it was a famous person, that is exactly like the original. But the actual text was so ridiculous and preposterous that Campari would have, be speaking of incest and outhouses in connection with a man of the cloth, that in fact it was unlike the original. So that's how the courts actually decide whether or not something's a parody. And that's what the courts use for evaluating whether something can be legally protected or legally subject to liability. I take the position that parody, that way of looking at parody, is basically a concept of incongruity, right? You just don't expect to see it together. So that'll give you an introduction to it, and I'll be happy to expand further after you hear from the experts, Sabine Jacques. So examples of political humor and the law. I don't have any great examples where there's been liability, and the reason for that is that under the United States Constitution, any type of political speech has a heightened level of constitutional protection. And it's in that context that the Supreme Court came up with this test, the one that they actually applied in the Falwell case, which was you can, for example, make fun of a politician for telling lies, or for in whatever way you want to make fun of them, but the politician can only sue you for defamation or intentional infliction of emotional distress or whatever, unless they will not win unless they can show that in fact you knew what you were saying was false or had a reckless disregard for the truth or falsity of what you said. Now, your example of a politician telling lies under the cover of satire would not necessarily fall into that same test unless they were saying that about another politician. In which case, the other politician would actually have to show that the politician that uttered these lies had knowledge of their falsity and reckless disregard of their falsity, but you would also have to show that in fact it was something that was demonstrably false. And I don't necessarily have an example of that for you, because the politicians that actually make the big news are ones that are sophisticated enough to know that they're not necessarily going to win that kind of defamation suit. Okay, so next is what about Judge Judy's humor? I watched Judge Judy to learn about sarcasm, not to learn about humor and the law. She is, I mean, it's humor and the law in the sense that she is making jokes in the context of a purportedly real legal proceeding. So that would be an example of a judge making a joke. And my observation earlier was that, in fact, judges get away with a lot more joke telling in the context of doing their job than lawyers. So I think I answered them all, and we can move on to our next presenter.